Okay. Hi, everybody. Before we start, I'd like to acknowledge the traditional custodians of the land on which I'm speaking from today, the Wurundjeri people of the Kulin Nation, and I'd also like to pay my respects to elders past and present. I also acknowledge the traditional custodians of the lands on which each of you are living, learning, and working from. I would also like to extend that respect to any Aboriginal or Torres Strait Islander people joining us today. My name's Benjamin Spivak, and I'm a senior lecturer here at the Centre for Forensic Behavioural Science, the Swinburne University of Technology. I'm leader of the Psychology and Legal Process Research stream here at the Centre. It's my pleasure today to be hosting you for the CFBS seminar series. The series invites leading researchers to present the findings from novel empirical research related to forensic psychology and psychiatry, behavioural science, law, criminology, and related disciplines. The seminar series is held monthly, and we have a number of exciting speakers lined up. Next month, we have Professor Matthew Lindqvist from Stockholm University, who will be presenting on the health effects of prison. If you'd like to be made aware of future seminars, please send me an email, which I'll put in the chat box shortly. I'm extremely excited to be able to introduce our speaker for today's seminar. Professor Tess Neal is an Associate Professor of Psychology at Arizona State University and a founding faculty member of ASU's Law and Behavioural Sciences Initiative. She's a scientist, a licensed clinical and forensic psychologist, and importantly, a parent of 2 young children. Her research focuses on understanding and improving human judgment processes, especially among trained experts. And her more applied work focuses on improving forensic experts' judgments in particular. Professor Neal has received funding from the prestigious National Science Foundation, and she has been awarded numerous research and teaching awards. She serves as editor for the Journal of Personality Assessment and Psychology, Public Policy and Law, and as an open science advisor for clinical psychological science. She was selected as a Fulbright Scholar in 2022 to conduct a project about how the different evidence laws of the US and Australia lead to similar and different patterns of judicial decision-making about psychological evidence, with the potential to inform revisions to laws governing the admissibility of expert evidence in both countries, which, as I understand, is what you'll be presenting on today. Is that right, Professor?
Yeah.
Okay, great. Today, Professor Neal will be presenting a talk titled Psychological Assessments in Legal Contexts. Are Australian courts screening out junk science? The subject of the talk is, of course, extremely important, and research into this area is long overdue. As courts worldwide increasingly rely on psychological assessments to make a range of consequential decisions for those who appear before them, our ability to identify and screen out assessments that do not take a rigorous approach has become an issue of importance to more than just the psychological profession. This is why it is my pleasure to hear what Professor Neal has to say on the topic. Before I hand over to Professor Neal, a few things to note. Firstly, this session is being recorded and will be made available on YouTube for your viewing pleasure after the seminar. If you want to ask questions, please enter them in the Q&A section of the toolbar, which you'll find on the top right. You can do this at any time in the talk. We'll be doing a Q&A following the presentation. I'll select questions for Professor Neal to answer. We'll try to get to all of them depending on time. Okay, so without further ado, I'll leave it to you, Professor. Thank you very much.
Thank you so much for inviting me, and I'm thrilled to be here with you guys today. Like Ben suggested, I'm going to be talking about a project that I was working on as a Fulbright Scholar over there. I was there for about almost 5 months, from February through July of this year. So I've only been back here in Arizona for a month or so, and I miss being over there and miss being with y'all. Also, just so you know what's coming, this project is not done, and I'm going to be sharing with you where we are now with it and also what motivated it. So the whole beginning part is kind of why and how this came to be. But then toward the end, I will talk with you about where we are now with it, what data we do have, and we do definitely have some interesting data to talk about today. Hopefully my slides are going to work. Okay, so I'm going to quickly go through this beginning part because this is probably the audience that doesn't need to hear all this background, but it's still interesting. So I like to start when I'm talking with people about forensic psychology, and oftentimes I'm talking with people who don't know what it is. So I like to start with kind of giving a background on what it is. So what do people like Brendan Dassey, the kind of main character is not the right word. This is anyway, it was a documentary. One of the main people in the documentary on Netflix a few years ago. He has something in common with Andrea Yates, a woman who drowned all of her children in a bathtub. They both have something in common with Mike Tyson, a professional heavyweight boxer in the U.S. Several years ago. They all have something in common with Brad Pitt and Angelina Jolie, Hollywood celebrities, and Justin Bieber, a Canadian singer-songwriter, Daryl Atkins, a Virginia man who was facing possible capital punishment. And most recently, there's a show on Netflix right now, a popular show called I Just Killed My Dad. And this character, this person, also has something in common with all of these other people we just mentioned. What they have in common is that they were involved in some kind of legal case where there was a psychological question at something at issue that was core to the legal issue that was being decided. Each of those legal issues in each of those cases differed. So they were all the different kinds of referral questions were different in those cases, but the common factor was that there was a psychological question or feature at the core of some of those legal issues. The field that deals with some of those kinds of questions and tries to help the court come to answers about some of those things is called forensic psychology. And in America, about 7% of all of our licensed psychologists in the U.S. are practicing with either a primary or a secondary specialty in forensic psychology. I don't know what that number is in Australia, but I would love to know. So if anybody knows or can tell me where to find that information, I'd love to find it. Dr. Spivak also noted that these things are important because of the kind of gravity of the kinds of cases that psychologists are involved in when we're talking about how psychological assessment evidence might come into court. Things like, these are all US cases, but I know that in Australia you have similar types of referral questions. Things like parental fitness for custody, termination of parental rights, civil tort, or criminal compensation, I think is what you call it. Social Security, disability, that's entitlements, competence and or insanity, risk assessments, capital punishment eligibility, and so forth. You all in this audience probably know what these psychological assessment tools are or what the concept of them are and how they're related to forensic psychology, but a lot of people outside of this field don't. So I also like to talk about this and show this image. This particular picture I took of just the tools I had in my office and my colleague down the hall, another clinical psychologist. We went digging in our bookshelves and in our cabinets and pulling out all the different psychological assessment tools we had just to kind of give people a visual of what this is and what we're talking about. So given the stakes involved, one might think that the validity of these kinds of tests would always be carefully examined by the courts if this is the kind of evidence, if these are the methods that some psychologists are using as part of their expert evidence in court. In the US, we have evidence admissibility rules that clearly charge judges with screening out irrelevant and unreliable expert evidence. This started with a Supreme Court case that turned into a trilogy of cases. It was later codified in different types of law here. This is a firm part of our law now. It's not functioning well, but it's a firm part of our law. It's a challenging task. It's poorly executed. There's plenty of data about this now in lots of disciplines that courts are having trouble. They're having a difficult time screening the quality of evidence in psychology, but also well beyond psychology. This problem of how can a court screen for the quality of evidence across disciplines is a hard question, and a lot of common law countries they're dealing with this as evidence becomes more complex in cases. Most common law countries have seen the introduction of some more stringent evidence admissibility standards in recent decades. This is Gary Edmond, one of your Australian legal scholars, writing about things like this. The US was first in terms of some of these things. That Daubert case that I was just showing started kind of in the early to mid 1990s here. Canada followed closely the US approach. The Law Commission of England and Wales partially, they kind of started going to the US approach, and then only it was partially adopted and some things were changed and reduced down in some ways. And Australia basically said, we ain't doing that. So we will talk more about this, but you guys have taken a different approach. So in the U.S., what is this kind of Daubert standard? How is it written in a law? It basically says, judges, you have a responsibility to look at and consider the method that any expert of any discipline, if they're coming in and they're trying to offer expert opinion evidence, then the court, you as a judge, you have an obligation to ensure that that method used by the expert is reliable. And you can look at things like, they don't have to look at these things, but they can. This is kind of a checklist of things they could look at, but they can consider other things as well. And oftentimes they don't do this at all. So even though, the way I just framed it and the way the law reads, it sounds great, but in practice, it's not really working so well. Anyway, so they can do things like looking at whether the method has been tested, if it's generally accepted by other experts in that same field. That particular piece has a long history in law. The third is, has it been peer reviewed by experts in the same field? That peer review piece is really important, as we'll talk about in a little bit. And then what is its error rate? In Australia, you do certainly have an expert opinion rule, but it doesn't require the evidence reliability piece. So we have a similar rule that allows for expert opinion evidence, but then we also have the separate rule that requires the reliability of the evidence, and Australia does not. I'm not going to go through all these details, but your Law Reform Commission in 2005, and there might be more recent documents, but this is the one I'm most familiar with. Basically, your Law Commission said, we don't think that these things that other common law countries are doing, that they're rolling out, are gonna work. We think it's just sort of unnecessarily complex. It's not gonna have the impact that people think it might, and we don't want to do it. Arguably, they were right, potentially, even though on paper it looks better than what you guys have on paper. All right, so zooming back out, what's the purpose of this project? The fact that US and Australian judges operate with substantially different rules governing the admissibility of expert evidence offers a comparative analysis. It offers us the opportunity to kind of think about this and learn from what's happening with regard to the quality of evidence under these different kinds of rules. And if nothing's happening, maybe it doesn't teach us that much. But if something's happening, it could be useful for the way evidence laws are written. And in America, our Judicial Conference of the US is just now, they know there's problems with it. They just now revised it again and changed like a couple words in it. I don't think it's gonna make any difference at all, but people are aware that this is a thing that needs to be tried to be fixed. So what we are working on with this Fulbright project is extending out this paper that I'm going to tell you about in a second that came out in 2009 about the finding about admissibility of psychological assessment evidence in particular. We did this project in the US and published it in 2009. We're extending out that same project. So we're extending and replicating and extending in the Australian context. So that paper, the one that we're now extending to Australia, was called Psychological Assessments in Legal Contexts, Are Courts Keeping Junk Science Out of the Courtroom? It was published in a journal called Psychological Science in the Public Interest, which is, I didn't know this, but am excited about it, that it's the highest ranked journal in psychology. And probably because of the types of article it publishes, they publish things that would be in the public interest. So a lot of public is interested in it. So oftentimes they get press and that sort of thing. This one did get a lot of press, and that experience was instructive, I think, for in the future if I try and publish something that might get press about how I would do things differently. Because, of course, it was headlines like this, courtroom psychology tests may be unreliable. And that is partially true, but that wasn't the whole truth. And anyway, I'll leave it at that. So the purpose of that project, which is what we're replicating in Australia, was first, on average, how scientifically valid are the psychological assessment tools used by psychologists as evidence in court? And then once we know that, are the courts calibrated to that? Are they screening out the ones that are not so great? Are they letting in the ones that are better? And so it's a two-part project. One is a systematic analysis of psychological assessment tools used in court. So first we have to know what psychologists are using before we can see if the courts are doing a good job of differentiating the good from the bad. So, well, first, how do we know what people are using? And then later on, the next study talks about their quality. This one doesn't talk about their quality. This first paper from 2014, when I got started on this line of research, I did this when I was a postdoc, a forensic postdoc. And we were interested at this time in just figuring out what people were using. And I was particularly interested in finding out whether people were using anything to structure their judgment, or if they were using unstructured clinical judgment. That was what initially motivated the project. So we did this big study. We had a lot of data here. We had 434 respondents, and each of them responded on their two most recent forensic evaluations. So there were 864 cases in our data set. And they came from, it was an international sample, but it mostly was from the US. There was 7% of the sample from Australia. And it was interdisciplinary a little bit. It was almost all psychologists. There were a handful of psychiatrists and a handful of social workers, but mostly, well, I guess it was more than a handful of psychiatrists, 10% psychiatrists. Anyway, but they were an experienced sample, about 17 years of forensic evaluation experience on average. But what we did, I think, that was useful for this project is we didn't say, tell us about what you do on average or whatever. We specifically said, we want to know about your two most recent cases. So tell us, take out your most recent evaluation. What was your referral question? How long was your report? How long did it take you from the time you got the referral until you turned in your report? What kind of information did you use? Did you use any structured assessment tools? And specifically, if you did, an open-ended question to follow that up. What did you use? Tell us what you used. Instead of, do you use this tool? Do you use this tool? Do you think this tool is acceptable? So what that means is that that data is really difficult to deal with because it's a mess on the back end, but it's very useful for understanding what people are doing in the real world. So the first piece of result from that project was, this is what the picture looks like in that earlier project, which is mostly US, right? 76% of the sample in the US. It's clear that competence to stand trial was the most common referral question in this project. That is different than what's coming in your Australian sample in a little bit, which you all may already know, but I did not know that that would be the case. So violence risk was the second most common, sex offender risk third most common, and so on and so forth. In terms of how many were using tools, about 75% were using tools, and most use more than one tool on average in that earlier paper. One more point I want to make about that initial paper. Across those 864 evaluations, there were a total of 286 distinct psychological assessment tools that were used. That's a lot. And it was overwhelming in the sense that neither of the authors of, neither Tom Grisser nor I had heard of most of the tools that most people reported using in real forensic evaluations, which was surprising. And so we wrote a summary, in the 2014 paper about what we did understand, but there was a lot that we didn't know even how to deal with initially. That stewed, I worked on it for about 5 years. Eventually, it turned into what was the big paper, the PSPI paper, the Psychological Science of the Public Interest paper from 2009. Going back to now, that 2009 paper, on average, how good are these things? And then are the courts calibrated to them? So how do we know how good they are? We did a massive undertaking to rate the quality of those 286 tools. It turned into, because we didn't only use this data, we looked at other, anyway, we rated the quality of a total of, I think, 364 distinct psychological assessment tools. We used things like the manuals, articles in peer-reviewed literature, standards for what make good tools, comprehensive review sources, and used those to rate the quality of each one of the psychological assessment tools that we know clinicians reported using in real practice. So we used the standards for educational and psychological testing as one of our sources for how to rate the quality. We used comprehensive reviews, how other people had rated and summarized the psychometric quality of these tools, things like the mental measurements yearbook, but also other resources. The mental measurements yearbook, I think to this audience, I don't have to tell you what it is, but it's useful when I talk to judicial and attorney audiences. It's a great resource as a kind of first stop to figure out whether a tool has much validity or not. So in terms of how we coded it, we had a whole detailed coding process that was very intensive. I'm not going to go into details, but it was a heavy lift. There were 30 people that helped with the coding of that, so it was a major project, and very grateful to everyone who helped. Results. We coded not just the quality, but also those other indicators that the courts care about. Was it tested? Was this method ever tested? What's its error rate, and those sorts of things, and also general acceptance. So to deal with, to code whether or not each of these 364 tests was generally accepted in the field, we looked at 9 different papers, surveys of clinicians' attitudes and beliefs, and ratings of the acceptance of specific psychological assessment tools. So we used all of these to see how clinicians were rating the acceptance of the tools. Overall, these are our findings. Was it tested? This is the best data there are. This is the strongest they're going to look. Overall, 90% of the tools that we looked at had some evidence that they had been tested. Whether the method is generally accepted in its field, we found no evidence to be able to answer this question for about half of the tools. For the rest, we found clear variation, where a good chunk of them are clearly generally accepted in the field. But then there's a good handful where there are clinicians who are using tools in the real world, in real forensic practice, where it's clear that they're not generally accepted in the field, or the evidence is conflicting or unclear about some of the tools. Has it been peer reviewed / what is its error rate? We kind of rated this together in one item that we called overall evaluation of quality. To try and rate this, we found we couldn't rate it for about 37% of the 37% of the tests, because we couldn't find any evidence about overall psychometric quality. For the rest, we did find information about their psychometrics, and rated overall, found about 25% of those had generally favorable psychometric properties. 23% of them, of the ones that we found data for, no, that's wrong. 23% overall had some mixed qualities in terms of their psychometric properties, and then 15% were generally unfavorable. That's not great. Our courts calibrated. This is the second part, case law analysis. Are the courts scrutinizing psychological assessment evidence? Are they not letting in the ones that aren't generally accepted, the ones that haven't been subjected to testing, the ones that have generally unfavorable psychometric properties? The answer is no. They're not screening. But I can tell you how we know that. We know that empirically. The second piece of this, we had a whole team of law professors and law students who helped on the coding of the law data side of this. To do this project, we did not look at all 364 tools. We selected 30 of the tools, exemplar tools, we called them, that would they would be in different categories. So like on the top right, we wanted to make sure that we looked at the evidence for tools that had generally favorable reviews and were generally accepted. These are the ones that we would think the courts would be letting in. We also wanted to make sure to look at tools that had generally unfavorable reviews and are not generally accepted. These are ones that we would really hope the court is screening out. And then also we wanted to make sure that we were looking at some with mixed reviews and seeing how they were faring in the courts. Again, our analysis methods were detailed. They're in the paper. All of these papers that I'm talking about are available also freely online. But if you wanted any of them and can't find them, I'm happy to send them. 2 results. So the calibration results. Overall, this is the big picture finding, that basically there's almost never a challenge to begin with. So there's almost no analysis. There's almost no legal analysis where a judge is looking at factors anyway. Only about 5.1% of the 372 cases that we looked at in depth that we know involved the use of these 30 exemplar tests that we analyzed there was even any consideration by the judge about admissibility. When they did consider admissibility, those 5% of cases, it's still almost most of the time was let in. So only 32% of the time was it screened out. And only a handful of those were on validity issues. So there's definitely room for more challenge and more judicial scrutiny of what psychologists are doing. And psychologists can be doing a better job of picking good things to begin with. So the Fulbright project. Knowing that there are less stringent expert evidence admissibility rules are in Australia, are Australian courts nevertheless more calibrated to the quality of a psych assessment evidence than in US courts? I think there's some reason I think that might be the case. Our data are still too premature. We can't answer this quite yet. We need more data, but there might be some evidence that this is true. So this second question, what can we learn about the functioning of different evidence admissibility rules? We're not there yet. So part of my plea to you today is please respond to this if you haven't yet, and if you're relevant and eligible, and please recruit your buddies and your friends and get, help us get more data so we can share this kind of information with everyone that might be of interest to this. So when I was there, I was working mostly at UNSW with Christy Martiri, and then also some law professors, Gary Edmond and Marison Rock, who are helping with the law side of this project. The Fulbright project it's both of these things. So replicating and then extending to Australia, first replicating that 2014 paper, which is what we're working on now. Step 2 is the case law analysis, which is what we're also working on now. But again, we don't have enough data to really be into this yet. Step 1, I'm going to tell you what we do have to date. And then step 2, we're still in the initial stages of the case law part, but I will tell you where we are with it. So I'm going to share this invitation with you all. This is what the little flyer looks like. You may have seen it, you may not have seen it, I don't know, but I will try to beg you to participate in this study. Emerging findings. So right now we have 102 evaluations. So we have 47 people who have participated in this study. All of whom completed it. So we have each of those 47 people reported on 2 separate evaluations, and then there were a handful of people who reported on just one, which is fine. Even if you've only done one, it's fine. You can still participate. We can use a little bit of data. So overall, we have 102 cases, but they're nested within something like 52 evaluators. The emerging findings, mostly the people who are being evaluated, at least in the sample that we have so far, most of the evaluees are men. There's some women, and there's a handful of other cases involving families and so forth. It's mostly adults, and there are some children. Roughly 3/4 are reported using structured psychological assessment tools, which is 77%, which is a little higher, but similar to what we found in the 2014 earlier paper in mostly US data. So relative frequencies of referrals in Australia and New Zealand. This is mostly Australia, although it's open to New Zealand. There's a couple of people from New Zealand who have responded, but this is mostly Australia. Violence/recidivism risk is definitely leading in terms of the referral question that seems to be most common. Again, I will feel more comfortable with this data if we have more cases, but as of now, this is what it looks like. Violence recidivism risk as the most common referral question, sentencing, mitigation, disposition type evaluations second, then sex offender risk, child protection, civil suit/criminal compensation, competence to stand trial is definitely much less common in Australia than it is in the US. And then other kinds of cases, we have, a handful coming in on different types of things. Also, I don't know what an FASD evaluation is. So if anybody knows and can tell me what that is, I would be grateful. Of the 102 evaluations, there are 82 distinct psychological assessment tools. So replicating the pattern, the gist of the pattern in the earlier study. Here, there's a ton of different things being used by people. Almost no battery is the same as another. So they're basically no inter-rater reliability in terms of what people pick to use as their methods. But the exception is that there's some within evaluator standardization. So if we see 2 of their, they're saying, here's the details about 2 of my most recent evaluations, and I used tool A, B, C in both evaluations, then they look the same just within those evaluators. But there's a lot of variation between evaluators. 10 most commonly used tools thus far out of the 102 cases. The HCR20, some people were using version 2, some people are using version 3. That was the most commonly used tool. 19 of the 102 cases are reported using the HCR20. The PAI, 18 cases. The Depression, Anxiety, Stress Scale, 10 cases. Trauma Symptom Inventory, which in this count includes the Trauma Symptom Checklist for children and the Trauma Symptom Checklist for young children, 10 cases. Static 99, all versions, 9 cases. MCMI, RSVP, variations on the Wechsler Intelligence Scale, the LSIR and related tools, Paul Hess Deception Scales, and the Violence Risk Scale. Those last 3 were tied at 7 cases. Ones now that are highlighted are the ones that have the best. When we did the review of quality in the previous project, in the 2009 project, I went back and I looked at which of the tools had were generally accepted in the field, had overall favorable psychometric properties, and had been tested. I think if I already said that, then I can't remember what the third one is, and it's late. I'm sorry, my brain is kind of not working. But these ones are the ones that looked the best across all the categories that we rated before. So the PAI, the TSI, Static 99, Wechsler variations, level of service inventory, and the PDS are maybe the most robust tools out of all of these. That doesn't mean the other ones don't have good properties, and many of them do. But there's something about each of the other ones where there's some question about them. Other observations of interest that we probably don't have time to talk about, but I'm going to tell you anyway because I find them interesting. There's something called the armadillo, which you guys may know about, but I thought it was delightful when I saw that in the data because I'd never heard of it. It's an interesting name. The assessment of risk manageability of individuals with developmental and intellectual limitations who offend. There's both a sex offender version, I think sex offender or something like that is the S, and the general is the G. This seems to be an Australian-made tool, so I thought maybe y'all would find that of interest that it's popping up in the data that people are using this. The child abuse risk evaluation, the CARE, this is also popping up, which I think is also, if it wasn't sort of developed in Australia, I think there are some of you guys are doing some work on it. Child protection risk assessment, the CHIPRA, never heard of it. I will find out more about it, but if these are ones that I don't know much about that I'm going to have to do quite a bit of work on. So if you guys know about these things, if you want to point me to resources, I would love that. The meaning of the child interview, the risk of reconviction times risk of re-imprisonment, rock roll. I might be saying that totally wrong. Detection of unsafety in families. I think this one might also be an Australian one. Anyway, I think these are of interest and want to learn more about them. If you know more about them, help me find out what they are. So step 2, the case law side of this, where are we and where are we going with it? We developed an analytic method that is similar to what we did in the US version of this, but we're using Australian legal databases, which are different and have different pros and cons than the ones in America. But we're mostly using the OSTELI database because it seems like that's going to be a feasible and realistic way to move forward. It's also clear that this project is feasible. So when we first were sort of talking about the idea of it, the law professors didn't think this project had any legs at all. They did not think there was going to be any cases that were citing specific psychological tools. I'm glad we took a look because they were surprised and I think excited to find that there definitely are cases citing these tools. And so so far what we've done together is we took because we didn't have enough data to actually get started on this, but we wanted to know what the feasibility could be. We took the 30 tools that we had used in the 2019 paper in the US, and we just started with an OSTELI search on those 30 tools, not knowing if Australian psychologists were actually using them yet. But we just wanted to see if it was showing up in your legal cases. And they are showing up in your legal cases. So there's, for example, the Static 99, there's 807 legal documents that are discussing the Static 99. We don't know yet how many of these are in, discussing any kind of admissibility of them, but we will. We are going that way with at least some of these and looking at what's happening in these Australian cases. So hopefully we will be able to answer the question that we set out to answer but we don't know the answer yet. In the last, I don't know, 5 minutes or so that I have, I want to tell you about some other things that are going on that are building on this work and some opportunities in the future if people want to get involved in what I'm trying to do with things. We had a special issue that we put together that just came out earlier this year that was trying to figure out how to build on some of this work. So if we know that some of these things are being admitted into court, but maybe people don't know where to look to get high quality review of the psychometrics, and whether it's appropriate to use in a forensic context, what kinds of forensic context it might be appropriate for use in, and which kinds are not appropriate, what kinds of populations are these tools appropriate for use with and not. We had a whole special issue about some of these questions. I really wanted to try and get teams of people thinking and writing about particular tools, and this was a lot of fun to do this. It was also a lot of work and a lot of hard work, and the authors who did this, I'm very grateful to them, and I think they did a fantastic job with the whole special issue. So for example, we had a lot of adversarial collaborations, which is it's a model where you get people together who have sort of disagreements about something and you get them writing together. And this was one of them. The Rorschach paper was one of them. Y'all probably know what the Rorschach is. I'm not going to tell you what it is because you probably know what it is, but I will help you remember that this is a controversial tool, especially in a forensic context. I was very surprised in some of our earlier papers that I was presenting. I didn't zero in on Rorschach, but I will tell you that the Rorschach, I think, was the second most common, popped up as second most commonly in the actual forensic cases that we were looking at. So it's definitely still used in America, for better or for worse, but it's not popped up at all yet in the 102 cases in Australia, so it may not be used there. Or if people are using it, they haven't participated in this project. So this particular paper was one of the adversarial collaborations of this special issue, pulled people together who disagreed about the Rorschach and its appropriateness for forensic cases, and got them to work together to kind of review what the evidence was about the Rorschach and the RPAS, and then lay out where their areas of disagreement were and why they disagreed. And I think that has a lot of potential value for the courts and the attorneys and practitioners to understand why do people disagree, and where's the truth in all of this. There was a paper on using the MMPI-3 in legal settings. It's always sort of a challenge when a tool gets revised, because if the previous version of the tool had been admitted into court, and if there was evidence about how psychometric properties of an earlier version of a tool, they may not generalize to the newer version of a tool. And so this paper sort of tackles that problem with the MMPI-3. This paper is on the personality assessment inventory. Again, we have I think 12 or 13 papers in the special issue, and each one focuses in on one assessment, one very popular assessment in particular, to try and help everybody get on the same page about what it's looking like today. What is the evidence base for these tools today, which will evolve as time goes on, but for now, they're up to date. There was a paper on the MCMI, which is one of the most commonly used tools in Australia, at least in our data thus far. This paper was an adversarial collaboration, and it's a good paper. The trauma symptom inventory, again, one of the most commonly used tools in Australia. I think this one was an adversarial collaboration as well. The HCR20 involving some of your people at Swinburne. This one, I think it started as an adversarial collaboration. I don't know if it ended as one, but it's another good paper. So the opportunity to come is we are hopefully going to be doing another special issue. I think it's going to take a different shape than the JPA, the Journal of Personality Assessment special issue. But this one will be at Psychology, Public Policy, and Law. And I would really like for there to be more international authors on this. And so I wanted it to be already that we were already like kind of moving on this. Unfortunately, I've been slower with it than I wanted to be, but it's coming. So if people want to be involved, just look out hopefully for a call for papers. Oh, I was going to say about the JPA special issue. Every single one of those papers is open access, so they are free. They will be free in perpetuity. So you can get access to the whole paper without having to worry about it being behind a paywall. I'm going to end here. I'm going to put this Qualtrics link in the comments in case anybody hasn't participated and would be willing to participate, so we can build more data here.
Wonderful. Thank you very much, Tess. We'll start Q&A. So if you do have questions for Tess, just click on the Q&A button. Apologies, Professor Neal, and you can ask a question there, and I'll put that forward to Professor Neal. In the meantime, while we wait, I did have a couple of questions. That was a wonderful presentation, by the way. Really, really interesting, and kind of the first part was slightly concerning, given the large number of tests being used that didn't have any, seemingly have any evidence behind them. One thing it brought to mind for me was comparison with other disciplines that provide assessments for the court. So I'm thinking in particular medicine. Do you know, is there any kind of comparative work looking at how often they're using kind of evidence that is not reliable? Like, how does psychology stack up relative to other disciplines that provide evidence for the court, assessments for the court?
I think that is a great question. I don't know the answer to it. There might be a good answer to it that people could share. But a few thoughts in response, even though I don't know the answer. I'm going to talk anyway. And that is that psychologists, I really have taken this framing that I'm looking at the individual psychological assessment tools, which is what psychologists do. And in contrast, psychiatry and medicine does less of that, right? Like, this is kind of the domain of psychology. Psychiatry will do interviews, and they'll use clinical judgment more. And it's a medical model, and it's different than a psychological model that's based on psychometrics that has roots in the science of psychology, like kind of early on. We have different roots in our disciplines, and that affects the practice of what we do. So in some ways, on the surface and initially, it looks like us using tools and talking about psychometrics opens us up to criticism about the error and the performance of these tools, that if nobody's doing any empirical work on what non-psychometric kind of medical clinical judgment type approach on the surface, and yeah, it could open us up to more criticism. But the courts, at least in Australia, in the US, clearly they've said it doesn't matter. You have to follow the evidence rules. And what's happening with our forensic science, as forensic science is evolving and the whole system is trying to help figure out how to make forensic science get better, there's more and more attention to things like foundational validity and applied validity. And it doesn't matter if you're using psychometric tools or if you're using a medical judgment model. Those kinds of questions are coming for all of us. It doesn't matter which discipline you're in. If you're trying to bring expert evidence into court, that kind of analysis is coming for us all.
That's good. Another question. So for those instruments that had it, I'm kind of interested in any guidance you had for researchers who are looking to kind of validate tools and provide evidence. For those instruments that you found that had like some peer-reviewed evidence out there, what was the quality like, and what type of evidence do you think was lacking most commonly for the use of these tools?
Yeah, the thing that was lacking most commonly was any evidence at all. And so if there's any, that's already like a major step forward. So most of these things like didn't have peer-reviewed studies at all. And oftentimes there would be studies of things that were done before a tool, goes to market or something. But those studies get published, but they don't go through peer review in the same way that it would go through peer review in an academic journal. So a lot of those studies are published in the manual that then goes to market with the tool. I don't know if your pressures are the same in Australia as they are here. I know America has a more capitalistic kind of money driven culture, and that definitely is part of what's happening with the psych assessment tools here. So there's definitely pressure from the test publishing companies to get it to market, if it's a viable idea, to get it to market as quickly as possible. And there's no incentive to get it to peer review outside of the publishing, process with the company. And so that's obviously a disincentive for scholars who are developing these, or practitioners who are developing these, to get that kind of scrutiny by peers on the evidence for the tool. That said, there also is variation in quality of the peer review papers that are out there. So I don't know where you would want to go with that, but I'll just say that there is variation in quality, and also that there is so much room for more work in these areas, and extending out. Some of you guys in this group have done some really great work extending out how some of these tools function with minority populations and indigenous groups and whatnot, where we need that evidence if somebody's going to try and use that tool to assess a person that wasn't part of the norming sample to begin with. They shouldn't be using the tool, right? That there needs to be evidence before you're using a tool that will fit in the context of the tool that you're trying to use it for.
Thank you. Kind of segueing off that nicely, we have our first question. It does relate to kind of the reliability and validity of these tools across different cultures. So Jadip Sakar asks, what do we know about the reliability of tools that are of themselves valid and reliable, let's say for the general population, when used in a different culture? For example, US tools used in Europe or Asia. Gives the example of the Good-Johnson suggestibility scale. So tools that are, what do we know in terms of evidence for tools in terms of their cultural fairness across different groups?
Great question, and great empirical question. There's lots of assumptions about the generalizability of tools, and it is always worth looking at the evidence for the claims of generalizability, especially if you're if you're a scientist or scholar working on these things, and there's like unlimited room to do work in that exact question, right? There's so much that can be done in that space to figure out the answers to that question, and to provide the evidence that doesn't yet exist to answer that question. And shoot, I forgot my train of thought. I had a second part of the answer, but I forgot it. I think that's a great question, and there's huge opportunities for providing more answers, and not just providing answers, but like actually doing it, like doing the validation studies to make it generalizable to a different context, not just it might be easy to criticize. It's harder to move forward and provide solutions, right? It's easier to break things down than it is to build things forward, but both have a role in moving the field forward.
Wonderful. Do we have any other questions? Doesn't seem that way. Okay. All right. On behalf, here we go.
Would we be any better off?
Pardon me?
I see a question.
Yes. So Melissa Wood asks, to what extent do you take into account professional guidelines developed by or endorsed by experts in the field? So, for instance, textbooks advocating use of specific structured professional judgment tools in court settings, or practice notes for expert evidence in local jurisdictions.
I didn't know about the concept of a practice note until I was in Australia, and I was talking with forensic scientists who were talking about, they call them annexures, but I think the idea is similar to what is a practice note in a jurisdiction. I don't even think we have those here. If we do, I'm not familiar with them. I think those are great. I think they're, in my opinion, I think those are certainly a way that the field could move forward. There's always a attention though with it, right? So where I did some of my clinical training in Massachusetts, there was a statute that said for this particular type, because there had been like, there was reason why there was a statute, but the statute, it wasn't statute, it was policy within the Department of Mental Health, but it had the power of law. And it read that if you were doing an evaluation of a sex offender risk, and if you're at the point where the person is maybe going to be getting out of custody, then you have to use, I think it was the static 99. I can't remember which tool, but it was written into the policy. Like, this is the tool you have to use, because the powers that be had decided that that was the tool that was the most psychometrically robust for the question. And they wanted standardization within, practitioners in that area doing the work, which on the one hand is good, because you're reducing you're reducing the differences between practitioners. So you're increasing standardization. You are probably increasing inter rater reliability. You probably are reducing some bias, especially if you're using a really structured tool like that one. But it also leads to complications, some of which involve, the usefulness of the tool itself, if there's criticisms of the tool, but also it impedes progress in the field itself. So what if the field develops a better tool, but there's no way to get people to use it because they have to use something that's now outdated? I'm not saying that tool is outdated, but I am saying, like, in principle, this kind of restriction on discretion of what we do could be problematic. So I think there's pros and cons to structuring what we're doing, more so than the structure we have now. I think we should be more structured than we are now, in the sense that we should have more standardization for how we're approaching a given referral question. We should not differ so much between us, but how to get there, I think, it's a big problem, and it will require, I don't know, lots of people thinking about it and working together if we're going to get there. I saw another question that popped up that I think was a great question. The question was, would Australia be any better off if we had a Daubert standard? I don't know. I honestly don't know. I was presenting to the Judicial Commission of New South Wales before I left, and I asked them that question. I asked the judges that question, and the chief judge was there, and all the other judges were kind of like looking to the judge, and some of them were like nodding their heads, but nobody said anything. And then the chief judge said, I don't think so. And I don't think so because I think it would be, the rationale was, I think it would be expensive and unnecessarily expensive. And I don't think it's going to make a difference ultimately, except it's just going to be expensive in terms of resources. So it's interesting to hear what judges are saying about that. I honestly don't know the question either. And just culturally, like as an observation, I went to a footy game, and while I was there, I was so confused. I understood the concept and what the rules were supposed to be, but then when I was there, like, the time clock didn't seem to, like, it just, things were happening by surprise. The game ended at a time when it didn't, like, came by surprise to me. But nobody seemed upset by that. Like, it just functioned in a way that felt chaotic and felt like it didn't have any rules. And yet the population of people who were present understood what was happening and sort of, it worked. It worked, even though it looked very different than how it works here in some of our big sports. And so the same thing is happening with these evidence laws in this. And what I mean by that is that on paper, in America, we seem to put things down on paper and create rules for things, and I don't know, try and get things on paper right. But then we suck in a lot of ways at actually doing what's on paper. But you guys tend to, like, kind of be the opposite. Like, you have fewer rules on paper. You have more kind of like, in principle, this is what we want. This is how we want things to be. But then it's like your society seems to be, like, I don't know, cooperating better to make these ideas work, even if there's not specific rules on paper. I don't know if, if that idea is real, but this is just my observations, and as I'm trying to chew through and think on some of these things.
Wonderful, thanks. I think that's all we have time for in terms of questions, and I wanted to thank you on behalf of everybody here